Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm. They're your hosts. They're practicing attorneys here in North Carolina. Also joining us from Whitaker and Hamer in the Morehead City office, Cassandra Nicholas. And we are talking about defining legal docs and terms. Going to go over a bunch of these. And Josh, you kind of got started on this because you're getting a lot of questions about them.
Yeah, the first kind of segment of documents topic I want to tackle is basically when you're, in situations where you're borrowing money from a bank or a lender, car dealership, mortgage lender, right? When you're borrowing money to buy a car, to buy a house, to put solar panels on your roof, new HVAC, whatever you're borrowing money for. The person lending you money, the lender, is going to want certain things from you. They're going to want certain things signed. They're going to want certain security agreements signed. And I think a lot of people in their day-to-day life, just kind of sign whatever the lender puts in front of you. Not that the lender's doing anything, sketchy or anything. They have their documents that they use. They're not willing to lend you money unless you sign the documents they put in front of you. Sometimes an attorney's not around. But so we're going to talk about that. So our firm, the law firm of Whitaker and Hamer, throughout all of our offices, we do a lot of real estate transactional work, right? So that it would be if you're buying a home, you're refinancing a home equity lines, even in a commercial context, buying a commercial building, an office building, investment property, 1031 exchanges. There are all kinds of the transactions that go under that umbrella real estate transaction, right? But let's say you're not paying cash. If you're paying cash, you ain't signing a lot, right? If you're paying cash, that's great. You're not borrowing money. A lot of the documents that you sign at your real estate closing or when you go to buy a car, it's because you're borrowing money. And so the first document, this is easy. A lot of people probably know what this document is, Cassandra, but the first document you need to be familiar with is your note. So what is a note?
Note is your promise to pay back the loan.
Right. So that's your contract between you and the lender, right? So if Joe's lending me money to buy a car, he's gonna prepare a note. It's gonna have my interest rate on there, right? If my interest rate can change, it's gonna be on there. My monthly payment's gonna be on there. Where I make payments to, for how long. But this note is gonna be the contract where we decide, hey, this is how you're going to make payments. You're going to make payments for, 5 years. If you stop making payments, these are the fees you're going to incur, default interest rate. This is the bad stuff that's going to happen if you're in default. And so, like Cassandra said, that's a promise to pay. So if you're getting a mortgage, you're going to sign your note, which is great, but you're also going to sign a deed of trust.
Yeah. That's right, Josh.
So what's a deed of trust?
You're going to sign a deed of trust as well. So I tell folks, we do this a lot, right? We do a lot of signing, and I know everybody out there, they're thinking about how exciting this sounds and how much they would love to do this every day. Because it really gets the blood pumping talking about notes and deeds of trust, man.
That's right.
I tell folks, usually when I'm reviewing these documents with folks, we talk about the note, and I talk about how important the note is. Because the note's really the thing, right? Like the note is your promise to pay. It's your agreement. It's everything really in a nutshell. The deed of trust is generally just going to basically incorporate the terms of the note and not even necessarily incorporate those terms so much as put the public on notice that that note exists and do what's called perfect the lender, whoever's loaning you this money, their lien on your property. So it's going to be, when we do a title search on property, we've got to look and we've got to see what's out there that's affecting title to this property. And so one of the ways we do that is we're going to search the local register of deeds, and we're going to see what's been filed on this property. And so that deed of trust is going to pop up during that search. And again, that's what's going to notify us as a title searcher and just the general public or anyone who knows to look that there is a lien on this property and that note exists. So that deed of trust isn't necessarily going to do much in addition to the note. So again, you understand the note and the terms of the note. That's usually what's going to be important to you. The deed of trust is just kind of the mechanism that puts folks on notice. And then in the event that you don't pay and there has to be some enforcement action taken against you, generally when there's a deed of trust, that is going to be foreclosure. And whoever loaned you that money is going to come and they're going to foreclose on that collateral, which is the property. But that's the gist behind the deed of trust?
Right. So deed of trust is really just there to secure the lender's interest in the home they just lent you money to buy. And so the deed of trust is never a short document. Deed of trust will run you 20 pages or so. And it talks about the foreclosure process, what happens once you're found to be in default on your note. So note's the contract. In North Carolina, in other states, it's not called a deed of trust. Sometimes it's called a mortgage. Sometimes it's called a security instrument. But anyway, something will be recorded, like Joseph said. And so that's if that's Josh Whitaker borrowing personally, right? I decide to buy a house. I'm going to live in that house. The lender will have me sign a bunch of docs probably, but they will definitely have me sign a note, and they will have me sign a deed of trust. Now, if Josh Whitaker LLC, right? Let's say I create an LLC. We've talked about LLCs on the show, right? So you can create all types of entities that, you can treat as another person, really, right? So we talk about trust, right? Trust can exist as their own entity. LLCs, corporations, you can create those, right? And if your LLC or your corporation or your trust wants to buy a piece of property, and you got to borrow money to do it, the bank's going to want you to sign a note. They're going to want you to sign a deed of trust, but there's probably going to be some additional documents. One of them being a very important document, a guarantee. And Cassandra, I know you run into those too. A personal guarantee. What does that do?
Definitely. So the deed of trust is talking about that foreclosure and everything if you were to default on the loan, but that only affects who the actual borrower is. So if that's an entity, and the LLC or whatever defaults on that loan, under the deed of trust, the lender could only sue that LLC to get their money. But if you, as the owner of the LLC, also sign a personal guarantee, that lender can then also come and get that money from you personally, not just from your business.
Yeah, personal guarantee is a very powerful document that some people, just think is a normal document. And so when, if you're, like you said, if I've got Josh Whitaker LLC is under contract, it's going to buy an office building. The local bank is going to lend me the money. They're going to have me sign a note, a deed of trust, but they're not going to be satisfied with that. Probably. They're probably going to want me to sign a personal guarantee saying, hey, if I default and you foreclose and you're still owed money, even after you foreclose on the property, they can get to me, right? And in theory, they can get to my personal assets. A lot of times you create an LLC because you want to protect your personal assets, right? It's one of the reasons you do it. And, if you borrow money, the bank can require you, it's their loan. It's, they can require you to sign a personal guarantee. And so you just need to be aware if you default on that, then they can look to the property to foreclose and recover whatever they've lent you, whatever the outstanding principal is, but they can also come after your personal assets. And so I meet with people, I would say at least once a month, who get sued, being foreclosed on, judgment against them, unsecured debt, cars or whatever it is. They default on the note. The lender's taken possession of whatever the asset was that the money got lent to purchase. So they've taken that, they've sold it, foreclosed on it, done whatever they need to do, and they're still owed money. And these people get sued personally, and a lot of them will be confused. And I'll ask them, like, "Hey, did you sign a guarantee when this happened?" And they won't know what I'm talking about. And then, sure enough, the other side produces a guarantee, and they're usually, these guarantees can be super broad. They can reach a lot of stuff. So if you're borrowing money as an LLC, as a trust, as a corporation, if your lender, that's a negotiable item. Right. So you can talk to your lender and say, hey, I want to borrow this money, but I don't want to sign a guarantee. Maybe they make you bring more to the table. Maybe they loan you less, higher interest rate. But that is a negotiable item. But this document and these guarantees are usually not very long. One I was looking at the other day is a page, but it has got super broad language, and it opened up this one client to some liability he probably didn't want. And so, again, I know Cassandra practices a lot of business law. I know I see that a lot. So a guarantee is important to know what it is, and maybe it makes sense to sign it, right? It's not something I've signed them.
That's the thing, man. You talk about how it's a negotiable thing. And I mean, technically, every term of a loan is negotiable in the broadest sense of the word. Like, you can negotiate the terms. But I think the practical reality a lot of the times, especially when you're dealing with big national lenders that have these standardized forms, is if you want this money, you're basically signing whatever they present to you. And, you know, you don't have a ton of leverage in that situation. Now, that's not to say you shouldn't advocate for yourself, and that's definitely not to say you shouldn't understand exactly what you're signing, but there's not going to be a ton of wiggle room. And that's why a lot of times we get to the point we sit with folks, it's like, you know, you're here, obviously understand this, but if you don't like it and you don't want to sign it, you're not going to get this money. That's essentially that's the trade-off.
Yeah, lenders a lot of times.
That's where lender shopping comes in too.
Sure.
That different lenders have different terms, and more localized lenders might be more amenable to that sort of negotiation.
Yeah, absolutely. And you can definitely, when time permits. Sometimes time doesn't permit. Sometimes you only have certain lenders that you can work with. But if you've got time and you've got the ability to, just like anything else, insurance, attorneys, right? Anything that you're gonna endeavor on like that, you can shop around but it's important to know what a guarantee is, especially for our business folks who operate their own, our self-employed business folks who operate their own LLCs, their own corporations, or if you've done some estate planning and you operate out of a trust. You know, getting a mortgage while you have a trust, there's not a lot of lenders who will lend to a trust. So there's some things that you have to work around. I know we're coming up against a break, but I also wanted to mention in this segment UCC fixture filings, right? So UCC fixture filings, you know what those are, Joseph? I know you do. I'm asking you, but I know you know what those are.
Yeah, man, I know what those are.
Oh, there's more.
Right? I thought that was just a closed-ended question.
No, open-ended.
Yeah, no. So we see, again, we talk about ways that lenders are going to, kind of enforce your obligation, because again, they can just sue you based on whatever your agreement is. They can get a judgment against you for whatever dollar amount. But a lot of times that ain't going to be worth a whole lot. A judgment's only worth what you're worth, right? So these UCC fixture filings, they'll be filed from time to time, and basically that's going to, whereas you can file a deed of trust to get a lien on real property, those fixture filings can be filed to put a lien out there on, you know, the personal property or the fixtures that are associated as well with your property, essentially.
Yeah, we run into those a lot. You see those a lot. Like if you're contracting with a pool company and they're going to lend you money, a lot of times they'll file what we call a UCC. UCC stands for the Uniform Commercial Code, which is a statute that is in most states, and it allows a fixture filing for personal property. So people who put in your pool may take a fixture file. They may file that as a lien on your property until they're paid off for your pool. So you can't sell the property without paying them off. You see it a lot with solar panels. You see it a lot sometimes if people need a new HVAC and they're making payments over time. You'll see that fixture filing. So anytime generators, I see that a lot with generators, right? So that's what a UCC fixture filing is. UCC fixture filings don't require you to sign them, so it'd be part of your note. It'd be part of your agreement that you signed with the pool company. They would say, hey, we're going to file a UCC fixture filing. And they're supposed to cancel it when it's paid off. Some do, some don't. We see that a lot too. But all right, that was a note, a guarantee, a deed of trust, and a UCC fixture filing. So there's some documents we see in the loan lender world that we thought it might be fun might not be the word. Yeah. It might be fun to define. So
God, we got to take a break so my heart can slow down from this fun.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm, hosts of the show. And of course, joining us from Morehead City's office, Cassandra Nicholas, also an attorney at Whitaker and Hamer. Just a reminder, offices conveniently located for you for Whitaker and Hamer in Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and as we mentioned, where Cassandra is, Morehead City. If you've got a legal situation you're facing, maybe you've got a term that you're just confused by, you can always contact the firm. 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what that call is about. An attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show, questions@theoutlawlawyer.com, and we'll use those on a future broadcast. We're back right after this.